Hello, sound check, hello. Hello, sound check, hello. Hello, sound check, hello. Hello, sound check, hello. Hello. Hi, my name is Lex and welcome to Lex in Motion. In this channel, I'll be helping you build your competence, confidence, and capability in law school. Start today by hitting the subscribe button below. New episodes are posted every Friday. Hello, sound check, hello. Can you hear me? For the one person on this stream, can you hear me, kapatid? Baka salita ako ng salita at nakamute pala ako. Hello, sound check, hello. 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 Can anyone hear me bago ako magsimula? Hello, sound check, hello. Hello, sound check, hello. This is a test. This is a test. This is a test. This is a test. 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 Hello, sound check, hello. Hello, sound check, hello. Yay! Hello, Eunice. Maraming salamat. Can you hear me, kapatid? Can you hear me? Yes, no, maybe. Hello, Ronald. Hello, Ronald. Hello, can you hear me? Kisha, thank you. Thank you at nandito ka. Yes, good evening. Alright. If you guys can hear me, can we start? Victor Reyes, good evening, bro. Glad that you're here. Kisha, thank you. Jigspin, alright. Alright. O, kung loud and clear, game na ba? Game na ba? Get your caudals and notebooks ready. Quick and dirty episode to because it's a reading matter. It's something na definitely hindi itatanong sa inyong prelims o midterms. Hindi ito itatanong. Dire-diretso lang to. Kung itatanong man to, makikita nyo siya under the umbrella of independent civil actions. Sige. Senju, hello. Game na daw, sabi ni Renvi. Alright. Pa-stretch naman. Dali lang before we go to lecture mode. Yan. By the end of tonight's lesson, you should be able to identify the rules that bind independent civil actions. 2. State the requisites for the applicability of Article 34 35 of the Civil Code. Identify the reason why Article 35 is considered the backstop or catch-all provision for independent civil actions. Okay. Yan. Uy, salamat, Lawrence. Glad that you're here. Thank you for joining us tonight. Sige, Christian Ray, maraming salamat at nandito ka. Rodel, good evening din, bro. Betonyo, hello. Sige, Article 35. May caudal ba kayo? Do you guys have your caudals? Pero kung wala, okay lang. You can press Command T on Windows, Command T on a Mac, or Control T on a Windows. I-google nyo na ang Article 35. Hello, Jen Al. Salamat at nanonood ka. All the way from Riyadh. Nasa Lowfill po. Good. Good. Can you share the link dito para hindi na mag-google ang mga kasama mo, kapatid? Usapan natin ang Article 35. Mabilisan lang to. It's gonna be a quick and dirty episode. Leo Jean, good evening. Sige. Okay na? Bukas na ba ang Article 35? If you have Article 35 ready, can you type the first word? First word ng Article 35. If you have it ready. Sige, if you have it ready, type in the first word. Hindi ko sasabihin ang sagot para sa mga tamad magbuklat ng kanilang caudal. Alright. It appears there are 1, 2, 3, 4, maybe 5 people. 5 people who have opened their caudals. Sige, let's start. Article 35 of the Civil Code provides that when a person claiming to be injured by a criminal offense charges another with the same, for which no independent civil action is granted in this code or any special law, but the justice of peace finds no reasonable grounds to believe that a crime has been committed, or the prosecuting attorney refuses or fails to institute criminal proceedings, the complainant may bring a civil action for damages against the alleged offender. Such civil action may be supported by a preponderance of evidence. Upon the defendant's motion, the court may require the plaintiff to file a bond to indemnify the defendant in case the complaint should be found to be malicious. Second paragraph. If during the pendency of the civil action an information should be presented by the prosecuting attorney, the civil action shall be suspended until the termination of the criminal proceedings. Sige. That's Article 35, kapatid. Basahin nga natin siya. Ano yung mga foreign sa pandinig? Mga bago sa pandinig under Article 35? Sige. I'll ask. Preponderance of evidence. Does anyone remember this from the previous lessons? Ano kaya itong preponderance of evidence na ito? What is it and what does it mean? What is preponderance of evidence? Nako, walang nakakaalala. Hello Audrey, glad that you're here, kapatid. Wala. Preponderance of evidence. Wala. Okay, preponderance of evidence. Greater weight of evidence, sabi ni Rodel. Maraming salamat, Rodel. You are correct. Ano ang mas mabigat na quantum of proof? Anong mas mabigat? Proof beyond reasonable doubt o preponderance of evidence? Ano mas mabigat? Reasonable doubt o preponderance of evidence? Pili kayo ng isa. Come on. Kaya natin to. If we're gonna make a quick and dirty live stream, it has to come from you. Ano mas mabigat? Reasonable doubt, correct. So, pinakamabigat ang reasonable doubt. Kasunod niya ay, anong kasunod niya? Tandaan niyo pa ba? Tandaan niyo pa ba anong kasunod na reasonable doubt? Sige. Wala. Limot nyo na. Clear and convincing daw. Very good. For those paying attention. Kasunod ng clear and convincing ay, anong kasunod ng clear and convincing evidence? Ano kanya kasunod nito? Preponderance na ba? Preponderance na daw. Okay. Sige. May mas mababa ba sa preponderance? Meron pa bang mas mababa sa preponderance of evidence? Michelle Villamora, you are correct. Proof beyond reasonable doubt to an earlier question. Substantial. Correct. Sige. Reading Article 35, meron na namang something na bago sa aking paningin. Bilang first year, first semester. What is an information? Ano kaya yun? What is an information? Sabi dito, if during the pendency of the civil action, an information should be presented by the prosecuting attorney. The civil action shall be suspended until the termination of the criminal proceedings. Sige, what is an information? What is an information? What is an information, kapatid? Baka meron pa tayong maalala dito. An information is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed with the court. Correct. Correct, Rodel. Napaka-active mo, kapatid. Malayo mararating mo. Sige, sa unang tingin, kapatid, ay parang yung Article 35 ng Civil Code ay parang ulit lang ng mga natutunan natin sa mga nakaraang provisions. At itong unang tingin na ito, kapatid, ay tama. Throwback mula sa Article 29 ng Preponderance of Evidence. This is the quantum of proof required for what? Admin cases. Ano? Preponderance of evidence is the quantum of proof required for blank. Hindi na ako magpapaquiz mamaya. Sige. Quantum of proof required for civil cases. Correct. Again, Miss Pacheco. We learned it under Article 29 and we're learning it again under Article 35. Throwback din mula sa Article 30, ang non-institution of criminal proceedings. However, I feel like I'm getting ahead of myself, so let's just break down muna yung Article 35. Try to understand each of its parts. Article 35 of the Civil Code speaks about a scenario where a person is injured by a criminal offense. However, in this scenario, there is no independent civil action that is granted by the Civil Code or any special law. Yes, no. Parehas pa ba tayo ng naiintindihan at binasa? Ang ginamit na halimbawa ni Justice para sa kanyang libro is unintentional abortion. We can find an unintentional abortion under Article 257 of the RPC. Article 257 of the RPC. Basa, buklat kodal. Control T for Windows, Command T for Mac. New tab. Let's open a new tab. Ano ba tong unintentional abortion na halimbawa ni Justice Paras? Anyone? Wala. Hello, Miss Carlos. Good evening. Thank you for joining us tonight. Wala. Anyone? Okay. There are no answers from you guys. Article 257. Should I type it? Type ko na lang ha. 257. Article 257. Sige. Hanapin natin ano to. Let's educate ourselves. Hello, Jorge. Good evening. Rhea Lamelo says, it's imposed upon a person. Ano yung ini-impose? Unintentional abortion. The penalty of prison correctional in its minimum and medium period shall be imposed upon any person who shall cause an abortion by violence but unintentionally. Correct. Correct, Rhea. Ang dami mo ng correct answers. Ngayon sa libro ni Justice Paras, he speaks of a woman who accused her classmate of committing the crime of unintentional abortion against her. However, the prosecutor refused to institute criminal proceedings against the classmate. The woman's remedy now is to file a civil action for damages against the classmate. If for whatever reason the prosecutor files an information that charges the classmate with the crime under Article 257, then the civil action for damages shall be suspended until the termination of the criminal proceedings. Yan. Sige. Kung ikaw, kapatid, ay nagmamadali and you're watching this on replay dahil gahol ka na sa oras, so nagmamadali ka na sa iyong review, we can stop here. Article 35, after all, is a reading matter, so no pressure for you to remember much else. Pinaka-importante lang dito, kapag nag-file na si prosecutor, suspended na si civil action. Sige. Kailangan mo lang malaman talaga dito yung suspension. The explanation you will find in the discussion of the next provision. Next lesson, we will cover Article 36 of the Civil Code. This covers prejudicial questions. So, ang mahiwagang PJQ. Ang PJQ, kapatid, ay suking-suki pagdating sa midterms at malakas din maka-throwback tuwing finals. Okay. That's the end of the discussion on Article 35. Technically, pwedeng tapos na tayo dyan. Quick and dirty stream. Let's check the time. 15:25. Oh, pwede na yan. Do you guys want to learn more? You want me to continue discussing? Yes, no, maybe. Yes, no, maybe. Tapos na tayo sa Article 35. Yat na ang inabot ni Khalil na naghabol daw mula sa statcon niya. Good evening, bro. Tapos na tayo sa discussion ng Article 35. Eto, dagdag kaalaman na lang. But only if you want it. Yes, no, maybe. Sige. Yes, yes. Okay, for the 4, maybe 5 of you who said yes. Sige. Let's learn more. I want to talk to you about Article 35 at yung halimbawa na injustice para sa at least yung mga topics na tinamaan nila. Let's start with the crime of unintentional abortion. The elements of unintentional abortion are, number 1, there is a pregnant woman. Because there can be no abortion if there is no pregnant woman. Number 2, the violence is used upon such pregnant woman without intending an abortion. Okay? 3, that the violence is intentionally exerted. 4, that as a result of the violence, the fetus dies either in the womb or after having been expelled therefrom. Kung ikukumpara, sino ba ang may CRIM 2 dito? Parang baka lost kayo ha, kasi kayo ay nasa CRIM 1. Sabihan nyo ako if you need more. Kung ikukumpara naman natin sa infanticide, the child has to be born alive and viable. Bakit may CRIM 2 ka pa? May CRIM 2 ka pa ba, Mr. Canoso? Yan ang primary requirement ng infanticide. Kailangan buhay ang bata at kaya na rin niyang mabuhay to a certain extent. However, even if the child who was expelled prematurely and deliberately were alive at birth, the offense is still abortion due to the fact that a fetus with an intrauterine life of 6 months is not viable. The reckoning point is always 7 months. Not important ito, kapatid, pero nice to remember. Bakit ang reckoning point nasa 7 months? Ano basis, Canoso? After having admitted that you have taken CRIM 2. Jorge, mabot ka na ba dito? What's the basis? Bakit ang viability ang reckoning 7 months? Bakit hindi 6? Sige. On the 7th month of pregnancy, medical science teaches us that. Article 41 daw. Sige. Article 41 is the reckoning point. You read Article 41 on your own time, ha? Sige. Let's move on. Article 35, for its part, teaches us Khalil, i-PM mo ako sa problem mo ha. Kasi has nothing to do with 35 right now. Article 35 teaches us of the existence of the justice of the peace and the prosecuting attorneys. Capable of extrauterine life, correct. Sige. Sino ang justice of the peace? Sino tong prosecuting attorneys? Who are they and what do they do? As I've mentioned in previous streams, iwas na iwas talaga ako sa topic ng remedial law. Dahil alam ko sa sarili ko na tuwing nabubuksan ng kwentuhang rem, ay dadaldal na lang ako. So let's talk about how criminal actions are prosecuted. Kwentong rem to. Stop me if you're bored, ha? Pag anytime na ikaw ay na-bored na sa discussion, type bored sa chat box. Hihinto na ako. Dean Willard-Reano teaches us that the purpose of a criminal action in its purest sense is to determine the penal liability of the accused for having outraged the state with his crime, and if he or she be found guilty, to punish him or her for it. Rule 110 of the Rules of Court teaches us how this process begins. Sige. Section 1, can you open your codals? Command T. Basahin nga natin tong Rule 110, Section 1. Institution of criminal actions. Criminal actions shall be instituted as follows. A. For offenses where a preliminary investigation is required pursuant to Section 1 of Rule 112 by filing the complaint with the proper officer for the purpose of conducting the requisite preliminary investigation. B. For all other offenses by filing the complaint or information directly with the municipal trial courts and municipal circuit trial courts, or the complaint with the office of the prosecutor. In Manila and other chartered cities, the complaint shall be filed with the office of the prosecutor unless otherwise provided in their charters. Second paragraph, sabi naman, the institution of the criminal action shall interrupt the running of prescription of the offense charged unless otherwise provided in special laws. Sige. Sa ating pagbuklat ng Rules of Court, bagong-bago sa ating pandinig ang preliminary investigation. What is preliminary investigation? Sige. Look for it and type your answers. Sige, kapatid. Hinga muna tayo ng malalim before diving deeper into remedial law. This is something I'm awfully passionate about because this is where you actually see the law in action. Section 1, Rule 112. So, if you feel somewhat anxious about the idea that you have to take criminal procedure and civil procedure next semester, kung ikaw ay mga agam-agam sa dalawang subjects na ito, let me know by typing game sa ating chat box. Ikaw ba ay may agam-agam sa Crim Pro at Civ Pro? Type game. Type game in the comments below. Ay, chat box pala. So we're doing this live. Game. Sige. Huwag kang mag-alala, kapatid, for the 5 of you who said game. Hindi naman din siguro kita papabayaan. Makakapanood ka pa rin ng lessons sa Civ Pro at Crim Pro sa ating monthly subscription service. Excuse me. If you're excited about this, kapatid, let me know now by typing excited sa ating chat box. Parang may delay tayo. Rhea is correct. Preliminary investigation is found under Section 1 of Rule 112 of the Rules of Court. Preliminary investigation defined when required. Preliminary investigation is an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. Second paragraph, except except as provided in Section 7 of this rule. A preliminary investigation is required to be conducted before the filing of a complaint or information for an offense where the penalty prescribed is by law is at least 4 years, 2 months, and 1 day without regard to the fine. Without going into too many details, preliminary investigation, let's talk about that. There are 2 words here, preliminary. What does that mean? What does preliminary mean? Sige. Two words, preliminary. What does that mean? Initial, pwede. Pwede ang initial. Sa simula pa lang. What else? Before. Pwede yan. Before. Sige. How about investigation? What does that word mean? What does investigation mean? Tapos let's put them together. Preparation, preparatory, pwede. These are all correct answers. How about investigation? What does investigation mean? Examination, good answer. Sige. What else? Inquiry. Scientific inquiry parang malayo, pero yung inquiry we can accept. Preliminary investigation. Sige. Preliminary ibig sabihin in preparation of or in preparation for. Investigation on the other hand means fact-finding or more specifically an inquiry. Yes. Preliminary investigation, therefore, kapatid, means it is a process. It is a preparatory process. Ito ay isang paghahanda. Pero para saan? We now know that preliminary investigation is an inquiry or proceeding. And it is preliminary because it is in preparation of or a prelude to what? Prelude to what? No, next step. It's a prelude to a trial. The goal of preliminary investigation is to find out whether we have reason to believe that 1. A crime was committed. 2. The respondent is probably guilty. 3. The respondent should be held for trial. Notice kapatid ang precise language ng Section 1 of Rule 112. The inquiry seeks to find out whether or not we can come up with a well-founded belief, meaning may makatotohanang basehan. Assuming that we have that well-founded belief, this also has to be based upon sufficient grounds. Sabi ng Rule 10 kapatid sa ilalim ng Rules of Court, isang caudal na iyong gagamitin sa CrimPro at CivPro. Sana ay may kopya kang bukas ngayon sa isa pang tab. The process of criminal prosecution begins with the filing of the complaint, either with the proper officer or the municipal trial court and municipal circuit trial courts. Pupunta ang complaint sa proper officer kapag kailangan ng preliminary investigation. Now that we know what preliminary investigation means, let's go back and answer the question, who is a proper officer? Who is a proper officer? Sino kaya ito? Who is a proper officer? Section 2 of Rule 112 gives us the list of people who are the proper officers. Kulang kung sasabihin nyo na public prosecutor. Prosecutor, kulang. Kulang. Precise language of the law. Section 2, Rule 112 says, the following may conduct preliminary investigations. A. Provincial or city prosecutors and their assistants. B. Judges of the municipal trial court and municipal circuit trial courts. C. National and regional state prosecutors. And D. Other officers as may be authorized by law. Their authority to conduct preliminary investigations shall include all crimes cognizable by the proper court in their respective territorial jurisdiction. Nice. Ang tiyaga mo, Madam Monica. I-type mo lang yan. Sige. Ngayon kapatid, kailan naman natin kailangan ang isang preliminary investigation? Alam na natin na what it means. Alam na rin natin who are the proper officers. Question naman ngayon, kailan natin ito kailangan? Kailan kailangan ng preliminary investigation? Kailan kailangan ang preliminary investigation? Yes, Canoso, you are correct. But what is your basis? 4 years, 2 months, 1 day. Anong ibig sabihin yan? Minimum ba yan o maximum? Vague. So, lagyan natin ng basis. Ano yan? Maximum ba yung 4 to 1 na yan? Sagot. And what would be your basis? At least, ayan, at least 4 years, 2 months, and 1 day. Without regard to the fine. Saan naman natin ninakaw yan? Yang sagot na yan. You know, in law school, if you answer without legal basis, it's like building a castle in the air. You have no foundation. Sabi ni Jigs, sa section 1 daw ng Rule 112. Sa pagkakatanda ko naman ng Rule 112, ang section 1 ay definition muna. Definition, mahabang definition ng PI, followed by second paragraph. Yan. Second paragraph. Sige. The way my professor taught us how to remember the second paragraph of section 1, Rule 112, ay kinanta niya yung period, yung 4 to 1. 4 years, 2 months, 1 day. At ginamit niya ang kanta ni Brian McKnight, 6-8-12. Di ko alam kung, di ko na maalala paano niya kinanta. Pero syempre sintonado si ma'am. Pero nagpalakpakan pa rin kami dahil ayaw namin siyang magalit. So, anytime a crime is punishable by this period, minimum, 4 years, 2 months, and 1 day, a preliminary investigation is required. Below that, kapatid, pwede na nating idiretso sa MTC. There is an exception here. In chartered cities or those cities whose existence came about or those cities created by express provision of the law, like the city of Manila, ano pa ba? Legazpi City, Davao City. Sila ang exceptions dito. The exception to the exception is when the city charter provides otherwise. Sige. Halimbawa kapatid, sa krimen ng slight physical injuries, kung saan ang naging biktima ay hindi nakapasok sa trabaho dahil sa pasa o sa sakit ng katawan, ang akusado ay paparusahan ng pagkakabilanggo na 1 day to 30 days. Pasok ba ito sa requirement ng preliminary investigation? Yes, no, maybe. Pasok ba ito sa requirement ng preliminary investigation? Yes, no, maybe. The crime is slight physical injuries. The penalty is a maximum of 30 days. So, pasok ba ito sa preliminary investigation? Yes, no, maybe. Why not? Sige, assume na natin na hindi siya pasok kasi nga ang baba lang ng penalty. At ang minimum ayon sa rules of court ay 4 years, 2 months, and 1 day sa sintonadong tono ni Prof na hindi ko papangalanan. Saan natin siya ipa-file? Pwede ba sa MTC or Municipal Circuit Trial Court? Pwede ba doon? Yes, no, maybe. Sa MTC natin ipa-file ang complaint. Yes, no, maybe. Baba penalty eh. Diretso na ba tayo sa MTC? Yes, no, maybe. Interesting. Parang pa ba may no, may MTC, may yes, may no, may maybe. May maybe. Good. Joshua, Kenneth Lazaro says maybe. Sige. Not yet? Before we say yes, dun sa una kong question na ididiretso natin siya sa MTC, we have to check, where did the crime happen? Saan nanggulpi ang ating akusado? Saan nanggulpi ang ating akusado? Sa isang chartered city ba, gaya ng Maynila? O isang maliit na bayan, gaya ng Katubig sa Northern Samar? See? I hope you're visualizing yung kinds of questions na kailangan mo munang itanong. Yan. Assuming na sa isang malaking syudad, pumasok ba ito sa exception to the exception? Meaning, sabi ba ng charter, huwag niyong abalahin ang aming mga city prosecutor. Idiretso nyo yan sa MTC. Yan. Ayan kapatid, ang mga katanungan natin pagdating sa filing ng isang complaint that triggers criminal prosecution. Wait, hydration break. Ayan. I hope it's clear itong mga kinds of questions that narrows down where we can file. Sana hindi ka naman masyadong nalito sa ilang minutong nakaraan. If you think it's clear, kung may naiambag naman ako sa iyong kaalaman, kapatid, can you let me know by typing clear sa ating chat box? Sabi ni Emma Flor Orillaneda, no. Saan ka nalilito, kapatid? Or are you answering a previous question? Kung hindi clear sa'yo. Yan. Salamat at clear naman. Wait natin si Emma. Wait natin si Emma Flor. Saan siya nalilito? Or is she answering a previous question? Hindi. Emma Flor, do you have questions? Madam Monica, hindi clear. Sige, tanong nyo na lang. While we're on topic, tanong nyo saan nakakalito. Mas madali kasi itong ipaliwanag, kapatid, kung tayo ay nasa classroom. Tapos may blackboard na lang tayo or whiteboard. Maidodrawing ko sa iyo. Yung process. Where? Kasi we're narrowing it down. We look at the crime first, then we look at the imposable penalty. Alin man sa dalawa, pumasok ba siya o lumabas siya sa PI, you know where to go. Kung hindi siya pumasok sa penalty, katulad ng halimbawa natin, 30 days, MTC. Pero hindi mo muna sasabihin na MTC. You have to look at the venue of the crime. Where did the crime happen? If it happened in a small town, then go to the MTC. And end of flow chart. If it happened in a big city, is it a chartered city? Yes. If it's a chartered city, what does it provide? Does it provide that we can, it's the city prosecutor's job? Or pasok siya sa exception to the exception? At ibabalik lang din sa MTC. Para tong exception to the exception, medyo ano lang to eh. Parang di ko pa to nakita sa mga charters. Hope that clarifies that. Madam Monica, if you have questions, ask away. Habang tayo on topic. Hello, Moonshine. Thank you. Oh, while waiting for those questions, let's go back to Article 35 of the Civil Code. When a person against whom a crime is committed comes to the MTC, Justice of the Peace, functionally, or Office of the City Prosecutor, prosecuting attorneys, functionally, to file a complaint, and take note, this is the most important part. This is the most important part. The crime does not provide for an independent civil action under the Civil Code or special laws, and the MTC judge or the city prosecutor finds no probable cause to file a case or refuses to file a criminal case, then the injured party can instead file an action for damages. This action for damages can be proven based on mere preponderance of evidence. Katulad din sa ating mga unang lessons, a bond may be required from the plaintiff o ang taong naghahabla. Siyempre, always upon motion of the defendant. If for whatever reason the MTC judge or the city prosecutor changes his or her mind and eventually files the criminal case, then the civil case has to be suspended until the termination of the criminal prosecution. In so many ways, kapatid, Article 35 of the Civil Code is the catch-all provision of independent civil actions. Kung hindi pumasok sa ibang independent civil action, gaya ng defamation, fraud, physical injuries, kung hindi pumasok sa Article 34 or Article 2176, pwedeng-pwede siyang i-shoot under Article 35. Same rules will apply. A bond may be required, the quantum of proof is no longer proof beyond reasonable doubt, but something lower like preponderance of evidence. However, there is an exception, and I want you to write this down. The exception is when the prosecutor brings a criminal action. Sa ganitong paraan ay hindi daw ito tunay na independent civil action sa Article 35. Dahil kapag may prosecution, na-post na daw muna ang civil action. Hindi ito aandar ng kusa. It loses its independence. At meron ng impact o bearing ang magiging resulta ng criminal action. That's the big distinction here. Yan. Article 35 appears to be the catch-all provision, but it's not really independent in the way that other independent civil actions can proceed absolutely parallel with a criminal case. Sige. To summarize tonight's lesson, number 1, Article 35 speaks of a situation where there is no independent civil action granted by the Civil Code or some other law, but it is treated in the same way as an independent civil action. It's number 2, it stops being an independent civil action once a criminal action is filed by the city prosecutor or with the MTC judge. Number 3, preliminary investigation is a prelude to the filing of a criminal case. It is an inquiry to find out if there is sufficient basis to hold that a crime has been committed, that the respondent is probably guilty, and that the respondent has to be taken to trial. Number 4, when a preliminary investigation is not required, then the complaint may be filed directly to the MTC, except in chartered cities. The exception to the exception is when the charter provides otherwise. Sige. I know, kapatid, that I promised a very short episode tonight. Pero wala eh. Naungkat natin ang bungad ng criminal procedure. I hope you learned something new tonight. Wala muna tayong quiz. Kasi nag-live tayo. Sige. Let's look at a few questions. Hello, Herson. Ito, magandang tanong. Is the acquittal of the accused in the criminal case tantamount to a dismissal of the civil complaint under Article 35? No. The criminal proceeding under Article 35, if one is filed, aandar lang yan. But it does not mean automatically dismissed na rin yung complaint ng civil action for damages. Kasi it's very possible that procedurally ha, they are consolidated. Meaning yung kung ano man ang kiniklaim mo under Article 35 ay ipapasok na lang din kasabay ng yung criminal case. Pwedeng doon na kunin. Pwede ring kapag ang acquittal is based on the ground that the purported criminal act does not exist. Ayan. Tulad ng ating previous lessons. Kapag ganun ang ending, baka pwedeng hindi na magtuloy yung Article 35. Pero procedurally, it should continue. It only says suspension. Sabi lang sa 35. Suspension, yan ang topic ng prejudicial question. Haba ang ating next lesson. So, I hope you are all there. Sige. If there are no questions, it appears there are no questions, ha? Malinaw tayo. Let's end tonight's stream. If you would like to continue with the discussion on intro to persons, please let me know by typing yes in the comments down below. Comments na tayo mag-uusap. Thank you so much for watching. Thank you so much for being with me sa live stream na to. I will see you on Friday. Sa baba po ang mga yes. Sa baba ang mga yes. Wag dito. Sa baba ang mga yes. Hindi ko yan mababasa. See you on Friday.